Distinguished guests, ladies and gentlemen, welcome back. We will now commence the third session of the 13th Asia-Pacific ADR Conference. The main theme of this session is ADRs in Asia for construction and energy industry. In session 3, the Honorable Mr. Pyong-woo Im, partner at Kim & Chang, and Madam Abby Cohen-Smutney, partner at White & Case, will serve as our co-moderators. And we are also joined by distinguished speakers, including Mr. Yoon Jae-baek, partner at Yulchon, and Mr. Kevin Bo SC, CEO at Drew & Napier, and Mr. David Delman, Senior Executive Vice President at Samsung Engineering. And we also have Mr. Jonathan Humphrey, partner and chartered accountant at HKA. And last, but certainly not least, Mr. Steve Kim, Secretary General of KCAB International. Once again, it is my great honor to announce that session 3 will be presided over by the Honorable Mr. Pyong-woo Im and as well as Madam Abby Cohen-Smutney. So without further ado, let me hand it over to our distinguished moderators. Ladies and gentlemen, please welcome them with a big round of applause.
Well, thank you, everyone, and thank you for joining us again with your coffee. And we're going to now focus on construction arbitration. You know, construction, I think we know, gives rise to an extraordinary number of disputes, very often in arbitration. These disputes are complicated. They're very often multi-party, multi-contract, very often involving hundreds of millions of dollars in disputes, sometimes billions. So often the projects involve parties cross-border. There's an increasing number of mega disputes that we're seeing around the world, and there are a number of reasons for that. We all have increased energy needs around the world. We're going through tremendous energy transition, the rise of data centers to support our digital economy around the world. All of this is underlying mega projects, mega construction disputes are possible. And there are so many pressures for disputes, as we know. We're in an inflationary environment. There are geopolitical risks that give rise to all sorts of potential problems, difficulties, delays, and so on. So this is an extraordinarily important area for disputes, and we're now, with this very distinguished panel, going to discuss some aspects, some strategies, particularly from the Asia perspective, that we hope will be helpful and give rise to some interesting thoughts. Perhaps now let me turn to my co-moderator to begin the discussion, and we'll cover as many topics as we have time for.
Thank you, Abby. Okay, we start our session on the effectiveness of ADR before arbitration for resolving construction and energy dispute. The first topic is the pros and cons of mediation to resolve the construction dispute in ASEAN culture, and whether an escalation clause requiring mandatory step of mediation before arbitration is effective for that purpose. There will be discussion about how this kind of escalation clause could be used strategically in the real world. Mr. Delman will open the discussion, and Mr. Beck and Mr. Kim will make a comment thereafter. Dave?
Thank you, BW. So from a company's perspective, when we look out at the arbitration landscape, we see a very dark and frightening place. Dark and frightening, particularly since the COVID period. Costs, transaction costs for arbitration have increased dramatically. It's not unheard of. In fact, it's becoming quite normal to see international firms charge per the hour over $1,000 or £1,000 for partners, 900 or more for senior associates. Disputes can cost 10, 20, 30 million dollars. In fact, in a recent case, construction-related case, one party alone spent $150 million. When I go to my finance director and I say to him, it's going to cost $20 million to resolve this, I have to pick him off the floor because he just died of a heart attack. So what do? What's the solution? How do we get out of this? Well, one easy answer, not so easy, but an answer, avoid the dispute. How do you avoid the dispute? One mechanism is mediation. And I'm a big proponent of mediation. In my view, talking is always better than not talking. And sometimes talking is difficult because there is a disparity between the parties to their sophistication, to their goals, to their objectives, to their access to information. But if you believe, as I do, that there is something called objective fact, if not truth, but at least a fact, and companies are, in the main, rational economic actors, a full understanding of the facts, applying the specific contract terms in the applicable law, should lead rational economic actors to resolve disputes before tens of millions of dollars are spent. One mechanism that I've seen in the past is a contractual step of mediation. Contracted, put it in the dispute clause. Does that work? Unfortunately, at least in my experience, it does not. It does not work. It sounds good. Everybody going to go mediate and they're going to resolve their disputes. But the problem with the contracted dispute clause is the parties are not necessarily ready. They see that as simply a stepping stone to the main event. And that main event is a full tribunal with lots of disclosure and lots of expert fees and whatnot. So when does mediation, how do we make mediation work? What are kind of the ingredients? In my experience, a main ingredient is having a commercial mind. If you treat mediation as an adjunct or a part of the arbitration process, it's pretty much doomed. If you see it, though, as an opportunity to have a commercial discussion, getting to rational economic motivations, and you have an open mind to find solutions within that framework, it can become quite successful. And now what we do, we don't usually, if at all, engage external lawyers to do mediations. We'll write the mediation statement ourselves. We'll conduct the mediation without external counsel. And the reason we do that is that we want to make the point, we're here to have a commercial resolution. We're here to solve a problem, not create billable hours. And if you come to a point in which there is a better clarity as to the objective facts, and they do exist, sometimes they're hard to get to. You have that, you come with a commercial mind, not a legal mind. We found that sticking with structured negotiations may not settle on that particular session, but you get a good mediator who will remain in contact with the parties over time. My experience is inevitably it will settle. It will resolve. And the trick of it is to resolve it before I make the outside counsels rich. You want me to take a moment to talk about expert determination? You want to leave that?
Oh, that is the next topic. So I would like to say comment from Mr. Beck and Mr. Kim for the effect and pros and cons of mediation. Mr. Beck?
Thank you. Thank you, Byung-woo. Before start my comments, I may add some comments on Delma's story. If somebody asks me what is your specialty, and then in the past I said I'm a arbitration lawyer, but these days if somebody raised that question, then my answer is I'm a janitor or I'm a dispute resolution designer, which means after handling the construction dispute, there is no winner. During the first session, some speaker mentioned that their strategy is to win and again win the case. But in real life, there is no winner at all. If there is a construction dispute, that dispute arises because the expectations from both sides didn't meet. The owner's expectation is to complete the project within the period, not exceeding the original budget. The contractor's goal is to complete the project without spending more time and money. But the dispute arises when those expectations were not met. So when I deal with my client, I always tell them that don't be a winner. What you can get the best is to minimize your loss. So we have to design the dispute resolution method to minimize our case. So that is why mediation before the arbitration is so important. If we do not change the mindset of our client, the mediation or negotiation will not be helpful. But if we are very successful in persuading our clients and to change their mindset, then probably mediation is the better solution to minimize their loss within a very short time period and within a very little cost. So that is why I always recommend mediation before starting arbitration. So sometimes my client told me that YJ, you probably not a capable lawyer because you never recommend arbitration. But my goal is to give best benefit to my clients. That's it.
Okay, I really understand you are a good lawyer for the client's best interest. And Steve, do you have any comment?
Thank you. From an institution perspective, I share and I echo what David is saying. Structured mediation, a mediation clause that's been inserted into the process, is a bit of like a double-edged sword. So we have institutions from Singapore, we have ICC, we have ICSID. From institution perspective, when we see something like that, and we say, ooh, this is something that we could actually offer to the clients and whatnot. But when you reflect reality, and this is what exactly the challenge is for the institution, is you need to have sufficiently experienced case counsel or case management system to recognize and understand the atmosphere of that case. So you don't mechanically just say, we have mediation, do you want to do mediation? And I think this is one of the reasons why court-mandated mediation are not always effective. So I'm a realist in that I rather parties go through the arbitration process, and then for the case counsel to really listen and identify the case nature and see where they are. And we, as a third party, a neutral institution, could then offer our services without compromising the party's stance. So this is where the Asian ADR, the preservation of the relationship, the face saving, all of those factors come in that we, as an institution, as part of our service, we are recommending this at an appropriate, opportune time. So mediation, has lots of emotions mixed in it. And we recently had two cases where one was very successful in being mediated, the other one parties just were not into it, right? And maybe the timing of it. And it's that timing where we are trying to hit a moving target as an institution to successfully guide the parties into mediation. That's where the challenge. And I think that's part of the reason why the chairman was saying, we're going to go into a new direction and we're going to be growing as a team, not just in size or numbers, but from experience level, where we could say, you know what, some of the legal issues now have been identified, they've been resolved, it's now down to the numbers. That is when it's appropriate to actually then offer mediation without compromising anyone's position. They say, hey, have you thought about mediation? Right? And I think that would be the much more effective way, even from an institution perspective, to go.
Thank you, Steve. It is a bit surprising that Mr. Kim, as a part of a KCFE, promoting the mediation. because it can be a competitor of arbitration
Right.
and reducing number of cases. But anyway, for the best interest of your users,
Exactly.
I appreciate it. Okay, I do agree the Mr. Delman's point that the mediation is useful, particularly if the parties have a commercial mind. But in my experience, most clients show the suspicion about the mediation because it is non-binding. So now the time we need to discuss about the ADR with some binding effect. And as all of you understand, in the construction industry, expert determination with binding effect is increasing these days for resolving complex dispute. And Mr. Delman will share his experience in expert determination.
Thank you. So in our business, when a project goes wrong, it can go very, very wrong. And what I mean by that is not just one dispute on one issue, although sometimes there are bigger issues than others. Every issue becomes a dispute. Everything stops. The parties hate each other. They disagree with each other. They don't trust each other. They think everybody's lying to each other, which could be true. So when we see a project that just falls into an abyss of contention, what we try to do is to hive off, cut away the smaller issues, cut away the issues that are hyper-technical. A lot of times we get into what we call scope disputes, particularly with subcontractors. When you have a 2,000-page specification that's attached to the contract, and it's got 15 ways to install insulation on a pipe. The first way cost X, the last way cost 50% less. And of course, the subcontractor wants the most expensive because he gets to charge a big price, and the prime contractor wants the lowest because it decreases the price. And you can have, in a $6-7 billion project, hundreds and hundreds of millions of dollars in contention over disagreements over the interpretation of a specification. Do lawyers really know how to read a specification? Do arbitrators, do they want to sit for a month, 2 months, figuring out what kind of insulation was actually specified for this service? I suggest to you they do not. And those kind of very narrow issues that require true expertise in construction, because no specification is written perfectly. It's always subject to interpretation and always has a back layer of industry custom and standard that is kind of, oh, this is how it's done. Trying to convince a tribunal, oh, this is how it's done, even if it's an experienced tribunal, very, very difficult. So we have used expert determination, either binding or non-binding, but binding does resolve the issue quickly, to put those smaller, very concise, packaged problems so we can weed out to the major problems, to the major issues, and put those into a mediation, hopefully resolve it. So how does it work? Look, if it's going to be a very complicated mixed fact, requiring witness evidence, requiring interpretation of applicable law, expert determination doesn't work. An expert is not an arbitrator. You don't really want a lawyer as the expert, believe me. So you want to keep those kind of issues away from expert determination, but custom and practice issues, yes. You should really think about how can we package those things off and put them into alternative areas. And I often see, and have used successfully, contract clauses, dispute clauses that have an off-ramp of expert determination, not for all, but for some issues. And you can run these things in tandem. You can have the arbitration, hopefully you mediate it, along with expert determination, which can be exceptionally cost effective.
Thank you. As an outside counsel, outside the lawyer, I would like to say we could understand the specifications, but it's challenging, takes time. But anyway,
And
Jonathan?
lots of money.
Okay. Jonathan, you also have some point for the expert determination from your experience.
Yes, thank you very much. I mean, what David is saying is exactly right. You need to find exactly the right matter that is suitable for expert determination. And on these big mega projects that David's often dealing with, there are many different elements in dispute, and if you take the right ones, you can carve those out. But also we see, especially around sort of the engineering issues, big claims, like hundreds of millions of dollars around, are there defects with a boiler or are there defects with a turbine? And the answer is yes or no. If the answer is no, then there is no claim. If the answer is yes, there can be $200 million at stake. And what's the best process of that? To have one expert for the claimant, one for the respondent, arguing issue in front of a tribunal, and the tribunal, who is very knowledgeable and has dealt with a lot of these things before, but is not a technical expert. They're just listening to the evidence they're receiving and deciding who they think is more plausible. If you just have the parties making factual representations, and it really needs to be based on factual representations to have effective expert determination, and that expert can actually ask other questions around the issues that are being presented to it, then that can actually say, yes, there is an issue with this boiler or turbine, or no, there isn't. And that can eliminate a year-long plus dispute by just having that person who is an expert in building these boilers or turbines or whatever it is, to say whether it's right or not. And just having that get to the crux of the issue very early on makes everything else fall away, because any delay claims are arising because the owner is alleging that the boilers are defective. And then those delays in a power plant lead to delayed commissioning, which lead to consequential damages. All that falls away if an expert can just say, no, actually, I think this turbine is built, boiler is built correctly. So having that right expert with the right expertise to look at that one issue early on can actually eliminate a lot of the subsequent effort and time.
Okay, so based on what our two panelists said, expert determination is another useful options for resolving dispute, construction dispute early. But as you understand, the mediation and expert determination has been used or discussed for many years, but there is a new trend of ADR for construction, namely the early involvement of expert for resolving construction claim, not leading to the dispute. So in my understanding, the early involvement expert looks like a preconditioned upon that not inviting lawyers before the resolving the claims. So I personally have some reluctance on it, but regardless of my personal feeling, if it is useful for the resolving dispute, it is worthwhile to discuss. So Jonathan will open the discussion for the early involvement of experts.
Thank you, BW. I mean, I could send the room to sleep for talking for 2 hours on this, but I'll try and keep it to three elements. The first being the early engagement of experts, and you won't find an expert that wouldn't like to be involved earlier. Because we're normally kept out of it because the clients can have a misperception that it saves them money by involving experts later. But in reality, we find often it's actually the reverse. And I would, with my expert hat on, see the process being more following the process that third-party funders would follow. The first is early consideration of the merits. So is there a legal basis for the claim? So bringing in, say, engineering experts or delay experts early will tell you what the issues are and who is at fault, and getting that early assessment of, is the client right that the cause of the issue is X? or could it actually be Y? And that might come out later in the hearing, and then a claim falls away. Then funders want to think about money. What is the damage? How much are they going to receive? And if you don't bring the expert in early, the client can quite often produce its own assessment of loss, but very rarely is that assessment actually correct. I mean, sometimes it's in the general ballpark, but other times it's way off. And just 3 examples I've dealt with clients. I called it the good, the bad, and the ugly. So one, we had a client that just wanted to walk away from the contract, just wanted ended and walked away. But the lawyers actually got us involved to have a kick the tires to see whether there was any loss. We actually worked out the client had suffered a loss of 60 million euros. So on the back of that, they commenced an arbitration and won 60 million euros. Then the bad, I had a client, all the pleasings have been put in, and then the respondent asked for further and better particulars. The claim was for $50 million, went in and realized they double counted their claim. So the claim was actually for 25 million. And then the ugly is once went in, reviewed a claim, and saw that the loss was actually coming from a different area than was being pleaded, which meant that the client actually had to replead their case. So without that sort of, if you have that early involvement, then they can look at that and assess how to actually plead the case. Then I had a case, then you've got the third-party funders about thinking of enforceability. So if you get that early thought of enforceability, you can go and look at the way you can actually, if there are actually assets to enforce against. Then my computer's turned off. Great. Then turning to the early involvement of experts in the timetable with the interaction with the tribunal. Now, construction cases tend to lead the way with this, with a lot of joint statements prior to the commencement of the expert process, which brings the experts together and gets them, at least playing from a similar hymn sheet. And we're starting to see that go beyond the construction sector, which is actually being very positive. And recently I had a case where we had a document production exercise, and rather than the to and froing of the lawyers saying why documents aren't relevant, after the document production request went in, the tribunal actually called a CMC conference and wanted the experts to be part of it. And the tribunal asked, Mr. Humphrey is asking for this, you tell me why this is or isn't relevant. And the answers came back, well, actually, I'm doing a business valuation. Yes, I need those documents. Next one, do you need this? Yes, I need those documents. So rather than leaving it to the legal teams to have that, just the dispute that goes on, the obvious answer is always no in a document production exercise. Having the experts there and saying, yes, it's necessary, the tribunal then just ordered disclosure. So that was a very useful process to be involved that early. And then the use of experts at hearings. There's obviously the traditional way is the sequential cross-examination, and quite often there'll be a reserved period for hot tubbing at the end. 95% of the time, that hot tubbing never occurs. And either I and my fellow expert are doing an amazing job, or the tribunal has already made up their mind, or they've run out the will to live, they've got to get on a plane. But is there a better way to do it? And I was actually in a hearing in August this year, and it's a construction matter, where the tribunal made the experts sit side by side. It wasn't hot tubbing, it was sequential cross-examination. But with the experts there sat side by side, the tribunal could stop after an answer and turn to me or to my opposing expert after an answer I gave and said, what do you think about that? So it's more sort of an ad hoc hot tubbing, but a way to actually get the tribunal thinking about what they're hearing and in the there and then ask the questions to actually clarify their thoughts. So I think that's sort of throughout the arbitration process how experts could be used to better effect.
Okay, thank you. And again, I understand that Mr. Delman has some point as well for the early involvement of expert.
Yeah, I agree that early engagement of expertise is really an adjunct of getting to the objective truth or getting to the objective fact. As a responsible corporate officer, that's really my job. My job is to understand as best I can so I can advise my client to make sound business decisions. And using expertise to do that is, in my business, absolutely essential. The word of caution, however, I would add to that is experts can be, at least in my business, highly malleable. You get two experts looking at the same set of facts can come to diametrically opposed conclusions because they're in service of the client's interests, the divergent client's interests. And that doesn't help. So having good management and good focus working with the expert is absolutely essential. I'll give you one example of a very successful early engagement of experts without outside counsel. After the COVID period, my industry went through an amazing amount of upheaval. Every project around the world, no matter who you are, was delayed and disrupted. COVID was a catastrophic event. Sorting out who pays for that and how much they pay for that was a massive issue, trying to unwind all of those complexities. And you always get disputes between owner and contractor. What's the critical path and what impacted the critical path, and did COVID have anything to do with it? We got to those answers by having the owner appoint an expert, we would appoint an expert, and they would work together to look at the same group of facts, look at the same project schedules, and lo and behold, there was pretty good agreement over what, in fact, was the impact. And that allowed the parties to unwind these issues expeditiously and reset the project, and the project then completed successfully. So that's an example of how you can really effectively use experts.
Thank you. I think I have to find out some example of early involvement lawyer. It's helpful for resolving the dispute in construction side. But
In-house.
Okay. Anyway, our next topic is originally planned to ask Mr. Kim and Mr. Beck about whether the arbitration institution and arbitration practitioners promote mediation or not, but it was already sufficiently presented by them. So I would like to ask Kavinder Bruce SC, and I understand he has some experience, not ideal experience, that the ADR before the arbitration make the case complex, and the parties have some difficulties due to that.
Thank you. Yes, I mean, I've seen sort of DAB situations, dispute adjudication boards. We sometimes think that these perhaps might give a shortcut, simplify the dispute, but it comes with their own problems. I think in earlier panel somebody referred to DABs being, it's just another arbitration, and it's just as costly and just as much delay results. And there are other issues that happen. I was involved in a case where the issue was whether after the DAB had decided a matter, whether that decision could be turned into an award, and then this resulted in 4 court hearings around the issue of whether that award should be a final award, an interim award, or a partial award. I mean, extremely esoteric sort of stuff that gets lawyers excited, but the clients are shaking their head, the parties are shaking their heads and thinking, what in the world have we got ourselves into? So it's not necessarily a solution to all of it.
So, Blessy, I think your experience suggesting that even for ADR, some law institution to guide the parties and the decision making, the party, for the efficient case management is necessary and maybe helpful.
Yeah, I think that's right. I think the beauty of mediation is that it's going to be, if it's successful, the parties finding that solution. Obviously, it has to be commercial. The people have to have that perspective. But there isn't going to be an appeal. There isn't going to be esoteric arguments that are very interesting and probably very relevant from a legal perspective, but totally unproductive for dispute resolution. And so I think it is much more useful to be thinking about how we can optimize mediation and expert determination rather than only having things like DABs, for example.
Well, I wonder if you could elaborate, Cavender, a little bit more from the perspective of your experience as an arbitrator. What do you think about the idea of once the parties are before you as an arbitrator or a full tribunal, suggesting to the parties that rather than proceed in the arbitration, we should consider mediation or another solution?
Firstly, I think that's a great service that an arbitral tribunal can give to the parties. It can be really helpful in solving the situation. Arbitrators do a few things. One thing they do is they engage with the substance of the dispute. They decide it at the end, sometimes along the way. Another thing that arbitrators do is they case manage, right? But we fall into the trap of procedural order number one, and then that's case management done. But really, what Jonathan was describing, having experts come in early, that's not just going to happen. If arbitrators can initiate at a time when parties' positions have more or less become clear, initiate a substantive discussion with the lawyers, with experts, and say which part of this could be mediated. It doesn't have to be the whole thing, right? If the arbitrators could think, let's simplify the chessboard. Let's take a few of these issues. These are much better dealt with commercially. These other issues, I'm going to have to decide. And send some of it to mediation, some of it to expert determination. That can speed things up. Also makes the life of the arbitrator much easier. And I think that idea of mixing and matching, but initiating that after parties' positions have crystallized and initiating it in a substantive discussion with experts, I think that can be helpful.
YJ, can I ask you to comment on that a little bit? An arbitration starts, but then what do you think about the arbitrator suggesting to the parties to proceed with some mediation?
Yeah, my experience says even if arbitrators suggest mediation during the arbitration process, it's good. In my case, I had one case a couple of years ago. That's very complicated construction case, and we have all the experts. The determination, but the parties does not agree on that. So we started our arbitration, and after the first submission, our arbitrator recommended mediation without showing any preference, and he never hurt his independence or impartiality. At that time, the parties do not have any willingness to mediate, but the arbitrator, he explained the pros and cons of mediation, so parties reluctantly entered into mediation. The outcome was failure. But one good thing was 3 months later, the parties, they called each counsel and asked each counsel to suspend the proceedings. We asked why, and they said, during the mediation, the mediator, the third party, gave very clear guidance how they can resolve their disputes. So they are now very serious to think about early settlement. So that case, in 3 months later, they settled, and we lost our job. So I think the arbitrator, if they do not hurt their independence or impartiality, then it's better for them to perform their initiatives to persuade mediation. Thank you.
No. Cavender, what do you think? Is there a difference in attitude between those who are coming from a common law perspective as compared to those coming from a civil law perspective with this idea of commencing an arbitration but then hearing the arbitrator or tribunal suggest, you know, why don't you consider mediation?
I don't think that difference is as stark as some of us might suspect. I think there is a bit of a difference. You grow up in different legal cultures and you have certain norms, but arbitration lawyers have long since learned to deal with cross-cultural issues. I mean, most arbitration practitioners have dealt with cases where there are common law arbitrators and civil law arbitrators on the panel. They know how to talk to both. And I think that sophistication, I believe, exists in the international arbitration community already, makes it much easier to overcome these sorts of differences in our legal cultures.
YJ, I wonder if you can comment, still on this topic of considering in some contexts arbitration but incorporating mediation. What kind of guidance do you feel as the arbitration bar we need to do or to provide to the transactional lawyers? You know, so much, I think, often turns on the language of the dispute resolution clause. What more do you think needs to be done or could be done to facilitate exactly what we're describing here?
Frankly speaking, I think we have to educate our transaction lawyers. When I had that discussion with Claudia at the ICC, I told her that you do not come to Korea and you do not talk about arbitration. You don't need to do that. What you have to do is you have to meet the transaction lawyers and tell them how efficient arbitration and mediation is. Otherwise, we cannot work as an arbitration or mediation lawyers. So I think the best thing is that we have to do, in my firm, we sometimes do some internal education program to explain arbitration and mediation to our transaction lawyers. Whenever they draft the agreement, they only think about litigation in court because they do not know arbitration at all. If we talk about arbitration, then transaction lawyers' response is arbitration is kind of negotiation, so 50-50. So I said, no, it's totally different. It is probably a courtroom and the arbitrator is acting like a judge and they do not understand. So I think if we bring every dispute parties to mediation arbitration, we have to give them a willingness to participate. How we can they can assure their willingness to mediate to arbitrator is their transaction lawyer must give assurance to them. That is my thought.
Yeah, well, look, I think this is an important issue, and that would really make a difference for clients. Cavender, I wonder also if you have some thoughts, particularly from the point of view of an arbitrator, if you receive, a clause that is worded in such a way that it's challenging to know what is, carved off for possibly mediation versus arbitration, because I think that's what one idea that we have is to try to make it clear in advance for the parties that there's more than one way of resolving their dispute. Do you have any thoughts from the point of view of the arbitrator, how important it is, that drafting?
Sure. So I think it's very useful for the parties to be sensitized to what mediation is and what mediation could do to help them resolve their dispute faster and cheaper. A clause can do that, But if if the clause is drafted in a way that is limiting, define this type of issue is going to have to go to mediation first, or at some point it has to go to mediation. For the arbitrator, he or she immediately thinks, this is an issue of my jurisdiction. Because, okay, if that's supposed to go to mediation, am I supposed to deal with it? Am I supposed to deal with it now, or do I wait? And then a whole different set of problems, very legal sort of analysis starts going on in the arbitrator's mind. And that's necessary because that's fundamental. Is this within my jurisdiction or not? And that can be unhelpful because you don't want, again, another legal issue that's very, very important, but esoteric. And so I think the drafting needs to be very clear to stay away from jurisdictional problems, but yet sensitize parties to this option and even they could mandate that they consider it. I know a number of mediators who start out their mediations spending half an hour telling the parties why mediation is good. And it's almost like that's something that parties should get when they start an arbitration. Of course, that's not going to get drafted in the... Maybe the clause should really say, click this YouTube link and watch this video for the next 30 minutes or something like that. But sensitizing rather than creating a jurisdictional issue is what I would say about the drafting.
Yeah, David, I wonder if you could comment on that as well, because as we were talking about expert determination and technical issues that could go to an expert, better to an expert, what was going through my mind, perhaps too much as a lawyer, was, oh my gosh, jurisdictional bells were ringing in my ears. What is a technical issue? What, you know, are we going to have an arbitration about that? Do you have thoughts or experiences to share with the audience? Yeah.
So going back to some of the prior conversation, if an arbitrator in the course of the proceedings would come to the parties and say, you know, you really should mediate this or that, while the lawyers may have enough sophistication to manage that, to understand what that is, I can assure you my client would be aghast. They would be wondering, what's going on? Very suspicious. Why? Something's up. Something's underhanded. So I would be very reluctant to have an arbitrator or tribunal do that, even though it might be a really good thing. What I would suggest, and I've never seen it in any other rule, but if you would empower the arbitrator in the rules, in the institutional rules under which the arbitrator was selected, that he or she had the jurisdiction to do that, that would really solve a lot of problems. It would be good for the client to hear, well, that's in the rules, and that's what the arbitrator is doing. She is following the rules, and that would be instantly calming to the client. And it also solves the jurisdictional issue because the rules provide for it.
Could I?
Yeah, yes, please, I wonder.
I just wanted to make a comment and maybe ask this question of David. Don't worry, it's a softball question. In addition to putting it in the rules, do you think it would be helpful in that situation if, let's say, an institution had a protocol that, you know, published protocol that said at a certain stage of this type of proceeding, arbitrators should consider whether certain things could be hived off to mediation and so on and so on.
Absolutely.
You could point the client to that.
Well, it does really two things. It points that option to the client as existing well before this tribunal was appointed. Don't worry, they're not singling out you, they're not singling out this case. This is the way it's done. But if it's somewhere in the rules or in the protocol, in the procedure, then I think it does support the tribunal's jurisdiction. And there's one thing none of us want to do is to, including the tribunal, is stray away from that jurisdiction because that's the easiest way to get an arbitration award overturned. And that's not what we want to do.
Yeah, please, Steve, because also I think the drafting for parties is something very challenging, so an interesting service that the institutions could provide for parties.
Right, that's correct. So just taking 2 steps back, as I mentioned, this kind of echoes from session 1's discussion about, the needing to achieve the balance and basically providing additional education to not only to common law-based arbitrators or practitioners to understand the, shall we say, the flow, ebb and flow of the civil law-based jurisdiction, how they react, and it goes vice versa. As I mentioned, it's good to use the institution. So this is why we're here. I always tell the Korean clients who are very, shall we say, not skeptical, but who are very reserved on making certain challenges or vocalizing their displeasure with processes and whatnot, because what they don't want to do is being pegged as the troublemaker. And I always said, it's okay. This is why we're here. And this is why, as an institution, if we have procedures in which we do, to offer that service at an appropriate time as a third-party service provider who does not have any interest in the case. Now, to address the point of having a particular set of rules that actually then provide certain authority to the tribunal or the arbitrator to make that, yes, possible. We have international mediation rules that the parties could refer to. From an institution perspective, we take a very balanced approach. The party autonomy was mentioned. So we are very careful on going too far into details on providing certain revision of the rules that would encroach, or that makes it look like we're encroaching on the party's autonomy, saying, hey, we're providing this set of rules, and we have the authority, or the arbitrator has the authority to say, you could mediate this, you could mediate that. Right, so it's a very balanced approach for an institution perspective on it. So my recommendation or our suggestion is always use the institution, and it's important for us to have enough, should we say, experience, know-how, knowledge, 3 years of, should we say, managing cases, to recognize and understand when it is an appropriate time to provide and suggest that service, to make sure that the success rate is maximized, when we actually, recommend that. Right.
May I? Yeah, Steve, I have one question. You just mentioned about your function as the mediation service provider, but during the arbitration process, how institution can involved in the mediation process?
So, and this is going back to my older days. I'm actually from AAA ICDR, very classically common law-based institution. And to say that mediation is nothing new to the market. It has always been marketed. It now comes in a different package of hybrid mediation, arbitration, and whatnot. Even back then, what we did was we actually advised our case counsel to read through their files from beginning to end and identify cases that are mature enough for the case counsel as an institution perspective to offer mediation or suggest mediation services on it. I think the same process could be applied even to say a growing organization like KCAB International, right? To do that.
But as a counsel's perspective, this morning Joanne of HKIC mentioned about the HKIC's 2024 rule amendment. And in that amendment, they gave more flexibility to the arbitral tribunals. So I think if many institutions give more flexibility to the authority of arbitral tribunal members, then probably only with that provision, the arbitrators may introduce mediation during the arbitral proceedings. Then also that provision may ease the parties, the suspicions just mentioned by David.
Right. We tried that. We tried at certain other institutions, at least based on my experience. It had mixed results on it. And I think we go back to the point of making sure that the arbitrators are, whether that's through experience or through education, that they're well aware of the impact of their, you say, the recommendation, at the point of where they are recommending. And I think it is one of the possibilities that the institution can consider if we are to able to achieve that balance between, maintaining parties' autonomy, respecting parties' stance on it, and yet, should we say, being able to provide well-rounded services to the clients.
Yeah, yes, please, Jonathan.
Sorry, one last interruption. I'd be interested to hear from David. Like, going back 3 years to the conference circuit, everyone was talking about med-arb, med-arb, and any other variation you'd like to use of those words. Have you actually ever seen that happen in practice?
No.
Stephen, have you seen that?
We have seen, actually, recently, yes. It went from mediation, didn't work, went into arbitration. And it was actually filed as an arbitration back to us, right?
I've seen it work a couple of times, but I think with the Singapore Convention, it's med really isn't going to be necessary as much.
Yeah, I mean, I guess the verbiage that was used on it 3 years ago to be the next big thing, it just seems to be something that I've not really encountered. Which the concept seemed great. It's just that I think the practicalities just were never thought through.
Well, let's, YJ, let me turn to another mechanism then that we've talked about when we were preparing. The idea of a sealed offer. I wonder if you could speak to your experience with such a mechanism.
Yeah, actually, sealed offer is not common in civil law countries. It's commonly used in common law countries, and in my case, Korean clients are very reluctant to use that sealed offer, because if the meaning of sending out sealed offer means that they admit the other party's claims or his claim is not so strong, but actually, the sending out the sealed offer is a kind of good way to encourage the parties to think about early settlement. I mean, these days, if we talk about construction disputes, the cost of the arbitration proceeding is huge amount. So we always remind our client of such costs and the benefits of sealed offer. So these days, we are a little bit successful to using that, sending out sealed offer for the early settlement. And actually, we sent out one sealed offer last week and waiting for the other party's response. And I hope I could get a good acceptance from the counterparty. But these days, after we succeeded in 2 or 3 cases of sealed offer, some Korean companies really ask about the explanation for sealed offer. So if we are using sealed offer more frequently, then probably sealed offer will be a kind of the shortcut for this early termination. Early settlement. But one bad thing is some institutions have provisions to deal with sealed offers. So that case, if we do, for example, ICC arbitration case, we are using sealed offer frequently. But if we are doing arbitration under KCAB, as far as I understand, do not have any provision for sealed offer. So I encourage some arbitral institutions to adopt provisions to promote sealed offer mechanism. Thank you.
So Steve, please, what do you think?
So from having experience in both common law-based institution as well as currently the civil law-based institution, I've had experience with sealed offer both at my older job and my current job, and fortunately they both worked out well. And I will take to the point in that if it is the voice of the client, and exactly what the Chairman Chang said in session 1, this whole session is to listen to the voice of the client and the practitioner, in that if that is something that would then be making the process more effective, then we'll certainly consider that and incorporate that into the rules revision.
Okay. Now we will discuss some hot topics in construction industry. As you understand, the COVID-19, supply chain issues, and Russia and Ukraine war all of these circumstances resulted in sharp increase of cost and price in construction industry, and both of employer and the contractor are suffering of huge loss from this cost and price increase. So then the question arises whether the parties can seek the damage or compensation over their contractual entitlement, and whether it can be allowed under the contract and law, and how practically it will be established. So Jonathan will discuss this issue from the delay LD for employer and the cost increase, the prevention clause for the contractor perspective.
Yeah. Thanks, BW. I mean, part of this is to set up David and YJ on the experience and the legal background. But we are seeing more and more occasions where clients in the construction industry are wanting to advance claims beyond liquidated damages. Damages these days can be like icebergs. The liquidated damages can be the time and cost element, which is the 10% sitting above the water, but there can actually be substantial damage elsewhere resulting from a party's actions. So the first point comes is, is the dispute a contractual dispute? Obviously, if it's not and there's no LD clause, it's an insured event, it's a third party who is causing damage, then you can claim for loss of profits and any other loss that occurs. So that's all given. But what happens when there is an LD clause? In the old days, there used to be a lot of challenges to LD clauses, and we were engaged often to assess what actual damage was and to compare that to the size of LD clauses. But particularly in common law jurisdictions, that's sort of fallen away. It can have more of an issue in civil law jurisdictions still, but it all comes down to, is it a genuine pre-estimate of loss? And that's a loss calculated by generally two sophisticated parties many years ago, and yes, at the time it seemed sensible. But can you now revisit that due to cost escalation and issues that have risen there? Because actual loss becomes a lot bigger. But there's also other ways where you might actually be able to challenge liquidated damages clauses and a waiver of consequential damage. Quite often we're looking at claims around fraud and misrepresentation. So did a party actually have the ability to deliver what they were delivering? If not, then there's a misrepresentation there, and why should you be restricted to liquidated damages? I'm dealing with a case at the moment where an EPC contractor just walked off site partway through. So they're then claiming for general damages above the liquidated damages cap. And we're seeing a lot of the claims that arise obviously occur in delayed commissioning and performance guarantees not being met, whether that's sort of quality or quantity, increased operating costs, especially now due to delays. That's been a lot of escalation, but also if machinery is inefficient, then you're going to need more energy. And with energy prices now, that is one of the most significant costs you'll see in a lot of manufacturing companies, for example. And then you've got sort of financing costs. Now, financing costs can often be considered a direct cost, but to the extent you need additional monies, you need monies for longer because you're not making the profits to repay your loans, your loaning facilities, then you will be incurring additional cost. So these are all sorts of elements where there can be significant damage to parties, and we're seeing clients want to put those claims forward, and indeed are putting those forward, but then it comes to sort of the legal basis for getting around those contractual LD clauses, and I guess the hurdle you have to get over to show that they're not reasonable given the circumstances of the particular project. So I guess, David might talk to what you've seen, and then YJ might talk from a legal perspective.
They're usurping the moderator's prerogative. So
Now expert dominant, not lawyers.
This question is a really interesting one, but it is so highly dependent on the individual contract and the applicable law. So if the applicable law is English and the contract is written essentially properly, getting around the LD clause after the Cabinet Square Parking Eye decisions in 2015, which is 2 Supreme Court companion decisions, knee-high impossible. The legitimate interest test is almost insurmountable from a contractor's perspective. In civil law countries, liquidated damages can be viewed more as a starting point and can be adjusted. And particularly in the Middle East, the UAE law, Qatar, Bahrain, Saudi, it does give the civil codes do give the discretion to the judge or tribunal to adjust liquidated damage clauses. Price escalation is another matter entirely, and one that is bedeviling the industry because after COVID, everybody thought that's it, it's going to go back to normal. It didn't go back to normal and still is not, and it has a tremendous effect on the ability to execute these mega projects. And again, whether you can get relief or not, whether there's a basis or not, highly dependent on what the contract says and what the applicable law is.
I think I'm the ceiling of the liquidated damages. I think I speak too much. But anyway, liquidated damages is considered as the pre-estimated damages under Korean civil law. So there are some discussions to allow the suffering parties to seek for more amount beyond the ceiling of the liquidated damages. But so far, I didn't see any court precedent yet. Usually, the Korean court has a power to reduce the amount of liquid damages, but I did not see any opposite case yet. But it's my homework, and if I can find any good court precedent, I will let you or we know. Thank you.
So I could just add one thing. It's a slight tangent here, but it's a recent development if we expand Asia to APAC. And Australia has a concept of proportionate liability. So in the courts, a claimant, an owner, bring a claim against a contractor or EPC contractor will need to also join in those proceedings all potential subcontractors that may have a impact in causing the damage that has arisen. And the courts will then apportion liability for any award between those individual entities. And if a party hasn't been joined, then the owner will lose the right to the proportion caused by that entity. Now, there's been a recent finding in the Tesseract versus Pascali case where it went all the way to High Court. This was an arbitration. And the High Court found that proportionate liability actually also applies in arbitration. Now, that is going to cause many issues because you can't force a party to join an arbitration if they're not a party to the contract. So you could, as an owner, sue a subcontractor and a contractor, and they could find that a subcontractor is actually responsible for 50% of the loss. So actually their recovery will only be 50%. Now, there are options to opt out of that in certain states, but not all states in Australia. So it's just one thing to look out for and consider if you have any sort of Australian law clauses in your contracts.
We should just ask. Well, I think just given the time, we want to give an opportunity if there are any questions from the audience? If not, let me ask Steve, are there some issues that you think, from what you're seeing from an institutional point of view, that would aid the complex area of construction disputes, incorporate alternative remedies more effectively, or alternative methods more effectively?
I mean, my intention was for me to actually turn the table, looking at session 2, where I would actually ask the panel members and even to the audience members, from a institution service provider perspective, what your view is, what your views are on the market and the needs that you have at this moment. So, there was a voice throughout today's discussion about if we could give the tribunal the authority to actually then talk about mediation or suggest mediation, that would actually then ease off the suspicion from client, the Korea or Asia-based clients. There was a discussion about adding provisions to deal with the sealed offers. So my question then to the panel members and to the audience members is, just give me one homework for us to take back in considering in enhancing our rules and provisions, which we're doing right now, what you would like to see. You from major law firms to major corporations to to firms that dealt with small to medium-sized companies as well. So if I could just put the onus back to the panel members, just give me one homework for me to take back to the chairman, saying these are the things that we should actually consider if we want to make our process more efficient and to better serve our clients.
Yeah, David, and maybe before we naturally turn to you, let me, on that question, let me say that at least from my experience as counsel, for the tribunal or the arbitrator to have the authority is not quite enough, but that Cavender's suggestion, for example, of a protocol that sets out a certain specific guidance as to when and in what circumstance the tribunal should consider raising this or that would really be very important. I wonder if you could speak a little bit more to that, because what you said resonated with my experience, that if unexpectedly the tribunal said, why don't the parties consider X, I think many of the clients I've worked with would have become very nervous as well. What do you think? Is there more that, David, in your experience, that the institution should do to help that process along?
Yeah, so you wanted one thing. Homework. Yeah. Don't worry so much about party autonomy. And I say that because when I started, this talk, I said, look out at the landscape of arbitration. It's dark and frightening. The costs are out of control. The transaction costs are absolutely out of control. And parties don't know really how to deal with that effectively. And I would like the dispute resolution boards, the arbitration rules administrators, to view themselves more as dispute resolution organizations that have at their disposal a number of these things that we have been talking about that they can deploy with their objective is to resolve the parties or help the parties resolve the dispute, whether that be by final award or through expert determination or through mediation. It needs to be expeditious and efficient. And don't worry so much that one party or the other has autonomy, because sometimes that may not be such a good thing.
I wonder, Cavender, from your experience as an arbitrator, can you think of circumstances where it would have been helpful or could be helpful if there were specific tools, either by way of protocol or even institutional practices, that when we see this, we're going to urge the parties to do X, Y, and Z.
You know, arbitrators like rules. We're all lawyers. We like rules, and if the institution has a pattern, whether that's expressed in the rules or in protocols, it helps the arbitrator feel like, okay, this probably been thought through, and this is safe ground. The idea that seems to be developing here is I think both the rules and a protocol together would be important, because the rules might well deal with the power. The protocol would, as Abby put it well, you know, how to do it, when to do it. That might be useful. And just on party autonomy, I don't think that's a problem. Once you put it in your rules and the parties say in their dispute resolution clause, arbitration under the KCAB rules, they've signed up for it. That's party agreement to every single rule. So party autonomy has been respected.
And I raised the issue of party autonomy because I've spoken to a number of general secretaries of this or that, and it's always mentioned. The rules need to be, you know, respectful of party autonomy. Yes, you're right to an extent, but I also think the rules need to take account of changing circumstances. This is not 1950. They need to change. They need to evolve in dispute resolution centers.
If I may, I heard that there are some arbitration practitioners to try to include some period for the negotiating mediation in the PO1. So in that sense, the parties and the counsels can be proactive. They're suggesting to the arbitrator not a decision for mediation, but just giving us the period for the considering mediation in the middle of arbitration, even if that was not in the arbitration rules or parties agreement. So,
yeah, if I can just comment on that, I think that's obviously not unhelpful. But PO1 gets issued before the substantive memorials come. So it's not much different from the dispute resolution clause saying before you can start, there must be 30 days of mediation. It may be more window dressing than substantive. I think it would be better if in PO1 it said after the memorials initial memorials are in, there will be a substantive case conference and parties are to have their experts available. You know, something like that to then have that case conference be really the impetus for settlement and mediation.
Yeah, and I might just add in perhaps in closing, Steve, just to really emphasize what I think we heard here and also what my experience is. Once there's a dispute, very often the parties are just not going to both behave rationally, let's say, you know. And so the idea of party autonomy, and this might be what you mean, David, you know, the parties become a little irrational when that dispute arises. And so if the institutions have a sort of sorting protocol, when you have this type of issue, we will encourage X, Y, or Z, could really be that nudge that the parties would benefit from. So, well, we're out of time, so it's for me to encourage everyone to thank our wonderful panel for these really informative comments. Thank you all really very much, and thank you all very much.
So that concludes session 3 of the 13th Asia-Pacific ADR conference titled ADRs in Asia for Construction and Energy Industry. That was another round of passionate debate. We sincerely appreciate it. We will take a 10-minute break before session 4. Please feel free to help yourself with coffee and refreshments available at the lobby.